whether GECOM and or its chairperson can direct the CEO to produce his report under Section 96 of ROPA in accordance with the recount. The seventh and eighth respondents have also filed a notice of intention to contend that the decision of the court below be varied. They have brought to the fore other issues for determination of this court. That is to say, whether the learned Chief Justice was seized with jurisdiction to determine any of the issues raised in the fixed date application, other than the issue as to whether the Chief Election Officer was lawfully bound to comply with the directions of GECOM and or its chairperson pursuant to Section 18 of the ELAA. Alternatively, assuming that the learned Chief Justice was seized with jurisdiction, whether she failed to make relevant findings of fact and law from the affidavits and arguments of the seventh and eighth respondents. I first will deal with the issue of jurisdiction. In Daju and Tom, 1939 Law Reports of British Guyana, 263, it was held that it is the first duty of every court before adjudicating to satisfy itself on jurisdiction. It is appropriate, therefore, to commence by examining the issue of the lower court's jurisdiction before addressing other issues. The appellant submitted that the lower court was seized with jurisdiction to hear and determine all the issues raised in the fixed date application. The appellant argued that the first, second, and third respondents carry out public functions created by the Constitution connected with elections and are subject to the court's supervisory jurisdiction under Article 133 of the Constitution. Citing Holidar and Mingo, 2020 HC DEM CIV FDA 360 as authority for this view, the appellant quoted paragraphs 34 and 42 of that decision, which states, where an election official has not followed the process as outlined in the relevant statutory provisions, such failure is open to judicial review. And 42, there can clearly be cases where the court's supervisory jurisdiction can be invoked to ensure the correct and smooth operation or progress of the elections, proceedings, or process. The appellant also submitted that the learned Chief Justice correctly applied the decision of the majority of the Court of Appeal in Ulita Moore and GECOM, Civil Appeal number 38 of 2020. In that case, the court, by a majority ruling, endorsed the view that Section 140 of the Representation of People Act did not oust the court's jurisdiction to hear the fixed date application, and the court's supervisory jurisdiction can be exercised where the court is satisfied that GECOM has acted or is about to act in excess of its constitutional and or statutory powers. The appellant contended that the issues raised in this fixed date application concerned the validity of Order 60, and the first, second, and third respondents' failure to act within the confines of and in accordance with their constitutional and or statutory duties under the Representation of the People Act and were therefore reviewable. On the other hand, the seventh and eighth respondents have submitted the learned Chief Justice erred in holding that she had jurisdiction to determine any question beyond the issue of whether the Chief Election Officer was lawfully bound to comply with the directions of the Guyana Elections Commission and or its chairperson pursuant to Section 18 of the ELAA. They argue that the appellant is challenging the way GECOM has performed or is performing its functions, and this is prohibited by Section 140 of ROPA, except by way of an election petition. They submitted that the findings of the majority of the Court of Appeal in Ulita Moore, that Section 140, did not protect GECOM from judicial review if it had acted or was about to act in excess of its jurisdiction or statutory powers. The GECOM was protected from judicial review in relation to functions which fall within the responsibilities of GECOM and its management of the elections process, and that the validity of its acts and omissions in carrying out those responsibilities were to be determined on an election petition had to be read in light of the decision of the Caribbean Court of Justice in Ali and Jagdeo versus Eslin David, 2020 CCJ 10, Appellate Jurisdiction, Guyana. In Ali and Jagdeo, the CCJ determined that the Court of Appeal, in hearing David's motion, usurped the exclusive jurisdiction of the High Court under Article 163 of the Constitution, because Article 177.4 can only be invoked after a president had been elected. The seventh and eighth respondents submitted that the CCJ, in finding David's motion premature, endorsed the hallowed principle that any challenge to the validity of an election ought to be brought after the election has been declared and not before, as stated in numerous cases, including Narayan Kare versus the Election Commission of India, Punaswamy versus Returning Officer, Riaz Holida and the Returning Officer, and others, in by the full court in Bharat Jagdeo and Yuli Tamor and others, and the dissenting judgment of Justice of Appeal Prasad in Yuli Tamor, Gladys Petrie and the Attorney General, and C. Kumar Singh and another versus R.C. Butler. The seventh and eighth respondents also submitted that the Caribbean Court of Justice reiterated and emphasized the exclusive jurisdiction of the High Court under Article 163 to determine any question whether an election has been lawfully conducted or the result has been affected by any unlawful act or omission. They referred to paragraphs 45 and 47, where their honors emphasize at paragraph 45 that if the integrity of a ballot or the manner in which a vote was procured is questioned beyond the validation exercise, say because of some fundamental irregularity, such as those alleged by Mr. Harmon, then that would be a matter that must be pursued through Article 163 after an election has been concluded. And 47, whatever allegations of irregularity attended those votes, and we neither agree nor disagree as to the existence of such irregularities, must be adjudged by the High Court under Article 163, as was correctly stated by the chairperson of GECOM. The seventh and eighth respondents submit that it is significant in this regard that the Caribbean Court of Justice in this paragraph reference Section 140 in a footnote with the comment that the section provides that questions as to the performance by GECOM of its functions are to be inquired into only pursuant to the jurisdiction conferred by the Constitution under Article 163. Consequently, they argued that the decision of the majority in Yuli Timor was inconsistent with decisions such as Smith versus East LO Rural District Council, 1956 Appeal Cases 736, R versus Director of Establishments of Security Service, 2010 to Appeal Cases 1, Farley versus Secretary of State for Work and Pensions, number 2, 2006 1 Weekly Law Reports, 1817. The application of which would mean that Section 140 is not an ouster provision to which the traditional anismic analysis was applicable, but rather was part of a statutory scheme which allocates jurisdiction to determine the validity of GECOM's actions to a court other than the High Court exercising its common law supervisory jurisdiction. They submitted that in light of the decision of the majority in Yuli Timor, they submitted that in light of this, the decision of the majority in Yuli Timor cannot be considered good law. The relevant provisions of Section 141 of the Representation of the People Act and Article 163 of the Constitution provide, Section 141, except to the extent the jurisdiction in that behalf has been conferred, and the exercise thereof is required by the Constitution or any law made under Article 163 thereof, which provides for the determination by the Supreme Court of Judicature of questions as to membership of the National Assembly and elections thereto, and save as hereinbefore provided to the contrary, no question whether any function of the Elections Commission or any of its members has been performed validly or at all, shall be inquired into in any court. Article 163.1 provides that subject to the provisions of this article, the High Court shall have exclusive jurisdiction to determine any question be whether, 1, either generally or in any particular place an election has been lawfully conducted or the result thereof has been or may have been affected by any unlawful act or omission. In summary, these provisions seem to be saying that the court's ordinary supervisory jurisdiction is ousted from inquiry into whether GECOM and or its members have validly performed its functions or not, except under the exclusive jurisdiction conferred by Article 163 of the Constitution. It does not completely oust the court's jurisdiction, but provides jurisdiction by special procedure in the form of an election petition after the election has been declared. Article 141 of the Representation of the People Act is a partial ouster clause, as inquiry by judicial review into the validity of an administrative action is precluded, but inquiry by a particular statutory route is permitted. The full court in Ultimo recognized this distinction when it treated with this issue in paragraphs 84 to 88 of their judgment, which I will now read. Paragraph 80. We appreciate and are fully cognizant of the seminal decision of Annis Minnick as discussed above. However, we consider that the principles established in the cases such as Regina and Director of Establishments of Security Service, cited at paragraph 38 above, are equally relevant to the statutory framework that is applicable in this case, more particularly Section 140 of Chapter 103. Like the Director of Establishments, Section 140 provides for a mechanism to challenge any decision of GECOM, however made. This would be via an election petition. As recounted earlier, Justice Holder found that Section 141 of Chapter 103 does not oust the jurisdiction of the court in its ordinary supervisory jurisdiction for judicial review, where GECOM has done or is alleged to have done or intends to do something which it has no jurisdiction to do, or has acted or seeks to act beyond the powers conferred upon it by the Constitution. In so finding, Justice Holder relied on the dicta of Cummings, J.A. in application by Jariah Saran, cited at paragraph 13 above. He also relied on the strict approach regarding the application of complete ouster clauses laid down in Annis Minnick, finding favor with the principle that a provision ousting the ordinary jurisdiction of the court must be construed strictly, and that a meaning shall be taken which preserves the ordinary jurisdiction of the court. However, in so doing, we are of the view that Justice Holder would have erred when he failed to fully take into consideration and or apply the distinction between complete ouster clauses, such as considered in Annis Minnick, and other cases, and partial ouster clauses, such as considered in Smith versus East Ella Rural District Council, Director of Establishments and the Director of Establishments of the Security Service, and Farley versus Secretary of State for Work and Pensions, number 2 cited above. The position is clear from these cases that complete ouster clauses are to be construed narrowly, such that any error of law which goes to the jurisdiction renders the ouster clause ineffective and does not preclude the exercise of the court's power of judicial review. However, clauses which preclude inquiry into the validity of administrative action in judicial review proceedings, but either permit such inquiry if initiated within a specific time period or by a particular statutory route, will be held to oust the High Court's ordinary supervisory jurisdiction. In Regina versus Director of Establishment of Security Services, Lord Brown of Eaton under Haywood said at paragraph 23 of the judgment that, nor does Annis Minnick assist A. The ouster clause there under consideration purported to remove any judicial supervision of a determination by an inferior tribunal as to its own jurisdiction. Section 65(2)(a) does no such thing. Parliament has not ousted judicial scrutiny of the acts of the intelligence services. It has simply allocated that scrutiny to the investigating power tribunal. Similarly, in Farley, Lord Nichols of Birkenhead remarked at paragraph 18 of the judgment, the need for a strict approach to the interpretation of an ouster provision was famously confirmed in the leading case of Annis Minnick. This strict approach, however, is not appropriate if an effective means of challenging the validity of a maintenance assessment is provided elsewhere. Then Section 33(4) is not an ouster provision. Rather, it is part of a statutory scheme which allocates jurisdiction to determine the validity of an assessment and decide whether the defendant is a liable person to a court other than the magistrate's court. In our versus Director of Establishment of Security Services, the jurisdiction was allocated to the Special Investigating Power Tribunal and in Farley to another court. In the matter under consideration, Section 141 of Chapter 103 allocates jurisdiction to the High Court itself by a special procedure. The jurisdiction of the High Court is therefore not ousted at all, but Section 141 merely requires the particular issue to be dealt with by a particular procedure, that is to say, by election petition. Therefore, we hold that there is no reason to construe Section 140 narrowly, or as was done in the anismic line of cases, to make it inapplicable to decisions made without jurisdiction. It was the failure to appreciate the distinction between a complete and partial ouster clause that caused both Justice Holder and the majority Court of Appeal to err in Ulita Moore. The majority in the Court of Appeal noted that the evidence before the High Court indicated that there were matters which were being addressed by GECOM, which related to the execution of its functions under Article 177 of the Constitution and Section 99 of the Representation of the People Act. In paragraphs 85, 86, 88, and 107, the majority in the Court of Appeal recognized that an examination of issues such as whether the time had come to proceed under Article 177 of the Constitution and Section 99 of ROPA, whether to hold a recount or not, whether there was unlawful noncompliance with Article 177 of the Constitution and Section 99 of ROPA, whether Article 177 of the Constitution and Section 99 of ROPA were triggered, whether the recount was lawful, whether Section 22 of the ELAA was unconstitutional, and whether GECOM has utilized its powers under Section 22 of ELAA unlawfully, fell within the responsibilities of GECOM in its management of the electoral process, and was completely ousted by Section 140 of the Representation of the People Act, and could only be raised under the parameters of Article 163 of the Constitution in an election petition. Given the court's finding in this regard, it is difficult to see how the court concluded at paragraph 108 that the jurisdiction of the High Court can be exercised to grant relief during the election process in spite of Section 141 of the Representation of People Act. That jurisdiction can be exercised where the court is satisfied that GECOM has acted or is about to act in excess of its constitutional and or statutory powers. Section 140 is, however, effective in excluding the court's intervention in relation to the functions which fall within the responsibilities of GECOM in the management of the elections process. The validity of its acts and omissions in carrying out the responsibilities would, by virtue of Section 141 and Article 163 of the Constitution, be matters for determination in an election petition. It has been recognized that the High Court does have jurisdiction to intervene before an election is declared, where to do so would accelerate the completion of the election or acts in furtherance of the election, or to correct, smoothen, or remove obstacles in elections proceedings. See Election Commission of India versus Ashok Kumar, Civil Appeal number 6843 and 6844 of 1999, dated 30th of August 2000, Joseph Hamilton and the Guyana Elections Commission and others, 2001, number 40M, and Holidar. Hamilton and Holidar were concerned with elections officials who had not complied with the statutory duties imposed on them and were rightly subject to judicial review. In my view, those courts could properly review the decisions of the ROs because it was necessary to complete the elections process. And it did not go to the validity of the election itself. Whether or not they complied with their statutory duties was reviewable because they did not enjoy the protection of Section 140 of the Representation of People Act. In Ulita Moore, to inquire into the decision of GECOM and or its chairperson to sanction a recount of the ballots would involve embarking on an examination of GECOM's management of the elections process and its acts and omissions, which is expressly prohibited but for Article 163 of the Constitution. How else would a court determine whether GECOM acted or acted or was about to act in excess of its constitutional and or statutory duties? In the instant case, Section 141 of ROPA deliberately sets out that there can be no inquiry into whether GECOM and or its members validly perform its functions or not, unless such inquiry falls within the parameters of Article 163 of the Constitution. It was within this limited scope that the learned Chief Justice could have intervened to address the impasse between the CEO and GECOM. Had it not been for the majority decision of the Court of Appeal in Ulita Moore, by which Her Honor found she was bound, it is doubtful that she would have concluded that she had jurisdiction to examine any issue other than the impasse between GECOM and or its chairperson and the CEO. She was likely to follow her own decisions in Holladar in the High Court and Ulita Moore in the full court. In this regard, I find that the learned Chief Justice had no jurisdiction to interpret the constitutionality of Section 22 of the ELAA or the 60 or Article 177 of the Constitution to determine whether GECOM was acting lawfully, as this runs contrary to the jurisprudence as demonstrated by the CCJ's ruling in Ali and Jagdeo, that those issues properly belong in an election petition after the declaration of the final results. The next issue that I will deal with is whether GECOM and or its chairperson can direct the CEO to produce his report under Section 96 of the Representation of the People Act in accordance with the recount. It must be stated from the outset that the learned Chief Justice's jurisdiction to inquire into the impasse between the chairperson of GECOM and the CEO was not ousted by Section 141 of ROPA because the concern here is compliance by the CEO with his statutory functions and not the validity of the election. That being said, the appellant and fourth respondent contend inter alia that GECOM must declare the election on the basis of the declarations made by the returning officers under Section 84 of ROPA, since the recount process is inconsistent with the requirements of ROPA. They contend the person who is deemed to be elected president must be declared by the chairman of GECOM acting only in accordance with the advice of the chief elections officer. The respondents, excluding the third and fourth named respondents, contend that the CEO is an officer employed by GECOM and is subject to the direction and control of his employer. Further, GECOM is empowered to remove and exercise disciplinary control over him, and he is rendered by Section 18 of the ELAA subject to the direction and control of GECOM. Further, there is no provision in the Constitution or any other law which gives the CEO the power to direct GECOM. An examination of our electoral laws regime reveals that the CEO is a statutory officer subject to the disciplinary control of GECOM. Sections 18 and 19 of the ELAA expressly provide, respectively, that notwithstanding any written law, the CEO shall be subject to the control and direction of the Commission. And for the removal of doubts, it is hereby declared that the power of the Commission to supervise the functioning of any election officer shall include the power to issue directions to any such officer. Section 2 of ROPA defines election officer to include the CEO. Article 161A, 1A of the Constitution provides that GECOM shall be responsible for the efficient functioning of the Secretariat of the Commission, which shall comprise officers and employees of the Commission, and for the appointment of all staff to offices, and shall have the power to remove and exercise disciplinary control over such staff. Article 162.1 of the Constitution provides that GECOM shall have functions connected with the conduct of elections and shall issue such directions and take such action as appear to it necessary to ensure impartiality, fairness, and compliance with the provisions of the Constitution or any act of Parliament on the part of persons exercising powers or performing duties with the matters aforesaid. Section 22 of the ELAA empowers GECOM by order, if any difficulty arises in connection with the application of ROPA, to make provision, including the amendment of the said legislation that appears to the Commission to be necessary or expedient for removing the difficulty. Article 226(1) of the Constitution provides the GECOM is not to be subject to the direction or control of anyone. The CEO is therefore subject to the direction, control, and supervision of GECOM, acting in accordance with the entire electoral regime. That is to say, the Constitution, ROPA, the ELAA, and Order 60 made under the ELLA, and not the reverse. Therefore, the directions given by GECOM and or its chairperson to the CEO to prepare his report in accordance with the recount must be treated as a valid lawful directive, which the CEO is required to obey by virtue of Section 18 of the ELAA. Section 96(1) of ROPA mandates that the CEO shall, after calculating the total number of valid votes of electors which have been cast for each list of candidates on the basis of the votes cast and information furnished by the returning officers under Section 84, ascertain the result of the election in accordance with Section 97 and 98. In light of the fact that Order 60 is part of the present electoral law regime by which the CEO is bound, it can only mean that the CEO must prepare his Section 96 report based on the recount numbers. It is disingenuous for the CEO to insist on preparing his Section 96 report on the basis of the March 13 declarations when GECOM specifically issued Order 60 to cater for the various disputes and contentions that arose after polling day, as stated in Recital 8 of Order 60. The CEO cannot take it upon himself to arbitrarily disenfranchise scores of thousands of voters, as noted by the CCJ in Ali and Jagdeo at paragraph 47, where the court said, the idea that the CEO or GECOM could, in an unaccountable, non-transparent, and seemingly arbitrary manner, without due processes and the legal standards established in Article 163 and in the Validation Act, disenfranchise scores of thousands of electors is entirely inconsistent with the constitutional framework. Whatever allegations of irregularity attended those votes, and we neither agree nor disagree as to the existence of such irregularities, must be adjudged by the High Court under Article 163, as was correctly stated by the chairperson of GECOM. The appellant and the fourth respondent's contention that Section 18 of the ELAA is in tension with Article 177(2)(b) of the Constitution, and the GECOM can only act in accordance with the March 13 declarations in light of the fact that Order 60 was specifically created to deal with the controversies surrounding those declarations, is without merit. The validation exercise has been completed, and as noted by the CCJ at paragraph 46, the votes already counted as valid votes are incapable of being declared invalid by any person or authority. The CEO must abide by the instructions of GECOM and or its chairperson and prepare his report as required by Section 96 of ROPA using the recount numbers. The next issue is res judicata, the constitutionality of Section 22 of the ELAA, validity of Order 60, the recount results and the declarations of the returning officers for the 10 electoral districts made pursuant to Section 84 of ROPA. Given the finding of this court that the learned Chief Justice lacked jurisdiction to inquire into the constitutionality of Section 22 of the ELAA, the validity of Order 60 and the recount results, it is unnecessary to treat with these issues. However, for the sake of completeness, these issues will be considered on the assumption that the learned Chief Justice was seized with jurisdiction. With the exception of the third and fourth name, the respondents all contend that the issues of the constitutionality of Section 22, the validity of Order 60, and the recount results obtained pursuant to Order 60 are all res judicata. The appellant and the fourth respondent have submitted that these issues are not res judicata. The appellant contends that the conditions set out in Garraway versus Williams, 2011, CCJ 12, Appellate Jurisdiction, Guyana, to raise a successful plea of res judicata were not met. The appellant argued that Section 22 was addressed as a jurisdictional point and the validity of Order 60 was never raised in any court before because Ulita Moore predated Order 60. The appellant further submitted that the learned Chief Justice erred in interpreting paragraphs 106 and 107 of the majority judgment because that court was not declaring that Section 22 of the ELAA could only be challenged in an election petition, but also in a full frontal hearing as that of Misenga Jones. It was further argued by the appellant and fourth respondent that Ali and Jagdev concerned an interpretation of the words more votes cast and whether the Court of Appeal had jurisdiction to hear Eslin David's motion and were not decisions on the merits of the constitutionality of Section 22 of the ELAA and Order 60. It was therefore submitted that the learned Chief Justice erred in finding that the CCJ's decision endorsed Order 60. Section 22 of the ELAA and Order 60 made pursuant to Section 22 of the ELAA and the recount results obtained from Order 60 were examined by the majority court in Ulita Moore at paragraphs 105 and 105 to 107. Having set out the material part of Section 22 of the ELAA, the majority court applied Petrie and Sikumar and agreed that the examination of the constitutionality of elections-related legislation during the election period properly belonged to an elections petition. The court went even further to say that the determination of the question as to whether GECOM has utilized or utilizes its powers under Section 22 of the ELAA unlawfully properly belonged to an elections petition. At paragraph 106 and 107, the majority court said, we agree with the submission that the legality of Section 22 is a matter to be frontally examined by the court at a full hearing. In Petrie and Sikumar Singh, the High Court declined to examine the constitutionality of election-related legislation during the election period, allocating such questions to an election petition. The court said that such a determination would be disruptive of the election process. Moreover, it is well established that constitutional questions can be determined at the hearing of a petition discussed in Peters and Chaitan and the Attorney General and another 2001 63 Western Reports 244. Alternatively, if GECOM has utilized or utilizes its powers under Section 22 unlawfully, then this would be a question for determination at such time. No sufficient evidential basis exists for such a determination at this point. A full hearing as contemplated by the majority court cannot mean anything other than a hearing of an election petition by an election court with the presentation of evidence and cross-examination. The majority in Ulita Moore said just this at paragraph 89. An election petition which has the features of a trial according to the procedures set out in the National Assembly Validity of Elections Act and the rules would be the place for controversies central to the elections to be resolved by the High Court by way of evidence and cross-examination of witnesses. Submissions that the hearing of this matter before the learned Chief Justice amounted to a full hearing contemplated in paragraph 89, as contemplated by paragraph 89 by the majority court in Ulita Moore, cannot be countenanced. Reference in paragraph 107 to the possibility of GECOM utilizing its powers unlawfully under Section 22 of ELAA could only logically be referring to GECOM's decision to complete the electoral process by a recount of the votes in the ballot boxes, the validity of which properly belongs to an election petition. It is noteworthy that the majority court in Ulita Moore found in paragraphs 85, 86, and 109 that GECOM's decision to recount was within their functions to resolve controversies as part of its responsibilities to deliver results of the elections. The court endorsed the recounted paragraphs 85 and 86, which provides, the evidence before the High Court, as outlined, indicated that there were matters which were being addressed by GECOM which related to the execution of its functions under Article 177 and Section 99. Whether the time had come to proceed under Article 177 and Section 99 and the decision whether to hold a recount or not were matters that were central to the elections and fell squarely within the domain of GECOM to determine as part of its management of the elections. The functions performed in relation to those responsibilities would be shielded by Section 141. Based on the evidence before the High Court on affidavits, the High Court was not equipped to determine conflicts on the issues being addressed by GECOM or to find at that stage that there was unlawful noncompliance with Article 177 and Section 99. This, therefore, was not a fit case for the exercise of the court's supervisory jurisdiction and for mandatory orders to include the issue against GECOM. The majority court even went further in paragraphs 110 to 111 to say that it would be unlawful for GECOM to surrender its supervisory jurisdiction over the election process, more particularly the recount of ballots cast at the March 2nd elections. The recount process was also endorsed by the CCJ in the full judgment of Ali and Jagdeo. The CCJ spoke to the intent and purpose of Order 60 at paragraph 38 as being specifically introduced to cater for the various disputes and contentions that arose after polling day, and specifically after the March 13 declaration. It was this last declaration which led to Order 60. The intention was to provide an open, transparent, and accountable recount of all the votes cast in those elections. The purpose was to assuage the contestations among the various parties, determine a final credible count, and remove certain difficulties or fill certain gaps in connection with the application of the provisions of the Representation of the People Act. The Apex Court expressly determined the validity of the recount order and its process to be within the constitutional powers of GECOM as well as the legislative framework of Guyana's electoral system at paragraph 46, where they said, it is clear that under the legal infrastructure governing electoral process, unless and until an election court decides otherwise, the votes already counted by the recount process as valid votes are incapable of being declared invalid by any person or authority. At no time did the CCJ determine that a final credible count could not be established pursuant to Order 60, neither did it set aside Order 60. The constitutionality of Section 22 of the ELA, the validity of Order 60, and the recount results have already been traversed and addressed ad nauseum in both the Court of Appeal and the Apex Court, and found to properly belong to an elections petition after a declaration is made. These issues cannot be relitigated. Where such issues have already been decided, the courts have held that to allow a challenge to an outcome offends core policy against relitigation of identical claims. Garaway, which binds the parties in personam, can be distinguished from the present case, which concerns public interest litigation and the decisions of the court, which are binding in rem. Decisions of the court in public interest litigation have been recognized as creating a judgment in rem, rendering the issues raised res judicata. In 2006, the Supreme Court of India in the state of Karnataka and the state of Karnataka and all India manufacturers, AIR 2006-1846, for Sri Krishna J, giving the decision of the court, stated at pages 9-11, res judicata is a doctrine based on the larger public interest and is founded on two grounds. One being that no one ought to be twice vexed for one and the same cause, and second, public policy that there ought to be an end to the same litigation. The main purpose of the doctrine is that once a matter has been determined in a formal proceeding, it should not be open to parties to relitigate the matter again and again. As a matter of fact, in a public interest litigation, the petitioner is not agitating his individual rights, but represents the public at large. As long as litigation is bona fide, the judgment in a previous public interest litigation would be a judgment in rem. It binds the public at large and bars any member of the public from coming forward before the court and raising any connected issue or an issue which had been raised or should have been raised on an earlier occasion by way of public interest litigation. Attach whatever label you may, whether res judicata, estoppel per rem judicatum, issue estoppel, or cause of action estoppel. The fixed date application before the learned Chief Justice obviously raised impermissible, abusive, and duplicative litigation of issues already canvassed before the courts in both Ulita Moore and Eslin David, as noted in paragraph 7 to 9 of the judgment of the learned Chief Justice. And she was correct not to rehash those issues or to allow the court's processes to be abused. It is clear from the foregoing that the recount process undertaken by GECOM is germane to the discharge of its management of the electoral process and its functions to resolve those controversies. And its functions to resolve controversies to bring the elections to its conclusion under the existing electoral laws regime. Given that Order 60 contemplates the use of the valid votes obtained at the recount and the CCJ's pronouncement that the valid votes which were recounted must be used, the recount tabulations replace the March 13 declarations. The question as to whether GECOM properly set aside the March 13 declarations and ordered the recount under Order 60 is a question for the election court, as noted in paragraph 85 of the majority judgment in Ulita Moore. The finding by the learned Chief Justice that the March 13 declarations were overtaken by a credible count pursuant to Order 60 cannot be faulted. The law is pellucid. The court is stopped from inquiring into any matter which has the effect of vitiating an election, or using the words of Section 140, inquiring into whether GECOM or its members has validly performed its functions or at all, except under the exclusive jurisdiction of the High Court under Article 163(1)(b of the Constitution. This appeal and the fourth defendant's cross appeal is frivolous and vexatious and amounts to a further abuse of the court's process. It is a notorious fact that hostile and volatile conditions pervade the election season in Guyana, more so when cases surrounding the election are dealt with by the courts. In this regard, the words of Justice Pinard in Aubrey Norton, 1996 to 1998, Guyana Law Reports 373, at pages 387 to 388 of the judgment are apt and worthy of recitation. The learned Chief Justice Bernard stated, "It is incumbent on me to stress that at all times respect for our courts and orders emanating therefrom must be maintained, whether right or wrongly made. Judges strive to dispense justice under severe pressures and less than favorable conditions. Very often they make decisions which are not always popular. It is one of the occupational hazards, and we learn to live with it, provided always that we know we have decided fairly and in accordance with the law. However, we hope, and I trust that I speak for all members of the judiciary, that we do not have to carry the additional burden of political pressure from any quarter. We are here to dispense justice fairly and to hold the scales evenly. To put it simplistically, if the law is on your side, regardless of the identity of the litigant, you will win. If the law and judicial precedent is against you, you will lose. Justice must never be tied to political considerations and affiliations if we, as a democratic nation, believe in the separation of powers. That is the legislative, the executive, and the judiciary. The independence of the judiciary must be maintained at all times. Now, as the president of the Apex Court said in Ali and Jagdeo, the law must run its course. In the circumstances, I order the appeal dismissed, the cross appeal of the fourth respondent dismissed, the cross appeal of the seventh and eighth named respondents is allowed in relation to ground one of the notice by the seventh and eighth respondents of intention to contend that the decision of the court below be varied, and the court's jurisdiction to inquire into the constitutionality of Section 22 of the ELAA, the validity of Order 60 and the recount results are prohibited unless within the parameters of Article 163 of the Constitution. Assuming the learned Chief Justice's jurisdiction was not ousted, the issues raised in the fixed date application filed by Misenga Jones, to wit, the constitutionality of Section 22, the validity of Order 60, the recount results are res judicata. The issue of the validity of Order 60 and the recount results, which effectively set aside the declarations of the returning officers on March 13, 2020 for the 10 electoral districts, properly belongs to an election petition after the declaration of the results is made in accordance with the recount numbers. For avoidance of doubt, I find that the ruling of the majority in Yulita Moore was erroneous, insofar as it relates to the finding that outside of an election petition, the jurisdiction of the High Court can be exercised where the court is satisfied that GECOM has acted or is about to act in excess of its constitutional and or statutory powers. The issue of costs will be dealt with after my colleagues deliver their respective decisions. I thank you for your attention.
All right. By way of fixed date application, 2020 HC Dem Civil FDA 568, the applicant, Misenga Jones, approached the High Court for the following orders. I have recited all 29 of those orders sought, and I will not read them. Her application was supported by one Ganesh Mahipal, an accredited counting agent for the APNU AFC coalition at the March 2nd national and regional elections. Those supporting affidavits are a matter of record and will not be recited. Now, a brief background to these proceedings is warranted, if only for the purpose of context. As a result of the national and regional elections, various bitter disputes and contentions have arisen essentially as it relates to the results that should be relied upon by GECOM for the purpose of a declaration of a winner. Several court actions ensued, challenging, first of all, the declaration by the returning officer for District 4, C. Holidar against the R.O. Mingo and others, and secondly, an agreed to CARICOM supervisory count, Moore against GECOM. Subsequent to Moore's decision, GECOM issued Order 60 of 2020, which facilitated a recount process to be scrutinized by CARICOM. This process was completed. As a consequence, and upon a report being submitted by the CEO of GECOM, the chair wrote to the CEO requesting him to prepare and submit a report based on the recount results pursuant to Article 177(2)(b) of the Constitution and Section 96 of the Representation of the People's Act, Chapter 103. This spawned a third action, Eslin David against GECOM and others, Civil Appeal number 421 of 2020. The Court of Appeal, whose exclusive jurisdiction was purportedly invoked, held by a majority that for the purposes of Article 177(2)(b), GECOM must rely on valid votes cast. Upon an appeal from David's ruling, our Apex Court, CCJ, overturned the majority decision of the appeal court and nullified the report presented by the CEO. As a result, the chair again wrote to the CEO requesting his submission of a report based on Article 177(2)(b) and Section 96 of the RPA. There was non-compliance with this request, which prompted further correspondence to the CEO from the chair. The CEO responded by submitting a report which did not accord with the chair's request, but one which apparently reflected the 10 declarations submitted to him by the various returning officers pursuant to Section 84 of the RPA. It's the Representation of the People's Act. This prompted the chair to issue a ruling essentially setting aside those 10 declarations and replacing them with the certified tabulation of votes pursuant to the recount process. Upon another request by the chair for the preparation of the report, this fourth application was filed and engaged the attention of Her Honor, the Chief Justice. In essence, the applicant contended that Section 22 of the Elections Law Amendment Act number 15 of 2000 is unconstitutional, and as such, Order 60 issued by GECOM, which facilitated the recount process, is invalid. She called in aid the decision of the CCJ in Ali and Jagdeo against David, referred to earlier. Further, it was contended that there has been a violation of Section 84 of the RPA by GECOM's refusal to accept and act on the 10 declarations of the returning officers, which are still extant and valid. Additionally, the chair and GECOM is bound to accept the CEO's report in this regard, and the latter cannot be directed to utilize the recount results for those purposes. Upon a review of the orders sought, Her Honor at the case management conference identified 5 issues to be decided by the court. 1, whether this court has jurisdiction to hear the application. 2, whether Section 22 of the ELA, pursuant to which GECOM issued Order 60, is constitutional. 3, whether Order 60 and by extension of the recount results obtained therefrom are valid, such as to permit a declaration of the March 2nd, 2020 elections result based on the said recount results. 4, whether the declarations of the returning officers for the 10 electoral districts made pursuant to Section 84 of the RPA should be acted on or be set aside. And 5, whether these issues are res judicata, given the decisions of the Court of Appeal in Moore and of the CCJ in Ali. Her Honor, as a matter of law, based on a comprehensive decision, found in essence as follows. 1, on the basis of Holidar and the appeal court's decision in Moore, the court was clothed with jurisdiction, albeit limited, to hear the application before her. 2, on the basis of Moore's case, the principles of res judicata would apply, and as a result, the issue of the constitutionality of Section 22 of the ELA would be for an elections petition. 3, the appeal court in Moore's case and the CCJ in Ali and Jagdeo's case have already ruled on the validity of GECOM's Order 60, and as a result, the issue is res judicata. 4, the 10 declarations by the various returning officers cannot be resurrected. Additionally, the CEO is subject to the direction and control of GECOM pursuant to Section 18 of the ELA, as noted by the CCJ in Ali and Jagdeo's case. 5, based on the principles of res judicata and stare decisis, the relief sought, which are based on issues previously litigated and determined, cannot be granted. Her Honor's ruling attracts an appeal by the appellant and 2 cross appeals by the 4th and 7th and 8th named respondents. I have recited in full the content of those appeals and cross appeals, so I would not read it. Various written submissions were duly laid over by the parties actively engaged in this appeal, and oral submissions supplementing, expanding, and clarifying the issues that fall for determination heard. The industry and times ingenuity of counsel is noted and fully appreciated. I do not propose, however, to refer specifically to any of those submissions, but rest assured that they were fully considered and greatly assisted me in arriving at my conclusions on the issues in this appeal. As referred to earlier, Her Honor identified 5 core and peripheral interlinked and overlapping issues that fell for consideration before her. The parties to this appeal seemingly agree that Her Honor properly identified those issues, and as a result, her conclusions thereupon forms the basis of this appeal. Jurisdiction. This issue is been the main bone of contention between the parties as a result of the difficulties which have arisen in the aftermath of the March 2nd, 2020 elections in Guyana. This issue, once again, attracts this court's attention. Her Honor, in applying Articles 226(7), 163, Section 140 of the RPA and the jurisprudence emanating therefrom, the application by Aubrey Norton, Hamilton, and GECOM, Ulita Moore's case, and Holidar's case, found in paragraph 24 of her decision, where there is an impasse regarding the decision-making of GECOM to complete the elections process, and it is necessary to advance this process, which is still in progress. Judicial review is necessary to address this impasse. Her Honor, at paragraph 25 and 26 of her decision, went on, I have further concluded that in this context, there is a distinction to be drawn as regards inquiring into the functions of the chairperson of GECOM, the chairperson and GECOM, which are restricted by Section 140 of the RPA, and interpreting the constitutionality of the Section 22 and Order 60, as well as Article 177, to determine if they're acting lawfully, albeit these provisions speak to the powers and functions of the chairperson and GECOM. Thus, on this narrow basis, it is an inquiry into the legal framework that guides the carrying out of their functions to complete the elections process. If the legal framework is found to be unconstitutional and therefore void, then their functions and actions would perforce be affected. Now, this court by majority in Moore's case held that Section 140 of the RPA was incapable of protecting GECOM from judicial review challenges if it had acted or was about to act in excess of its constitutional or legislative mandate. However, Section 140 did shield GECOM from review in relation to functions which fell squarely within its responsibilities in its management of the elections process. Acts or omissions in the latter regard was for the determination by an elections court. Additionally, the majority went on to consider and referred specifically to Article 177, Section 99 of the RPA and Section 22 of the ELA in paragraphs 85, 86, 88, 106, and 107 of its decision as follows. I have recited those paragraphs. I wouldn't read them. It's well known to all of the parties to this appeal. I agree fully with the Honor's pronouncement at paragraph 24 of her decision. In the peculiar context of this case, judicial review is necessary to address the impasse in order to complete the elections process. However, in this limited jurisdiction cannot be invoked to resolve any questions as to the validity of an election itself. It is in this limited context, Her Honor was plainly correct in concluding that the CEO must act upon GECOM's direction to produce his report in accordance with the recount. This effectively resolved the impasse, thereby smoothing the elections process. This aspect will be considered a little more expansively later in this decision. Paragraph 25 of Her Honor's decision referred to earlier is of concern and does not sit well with me. Her Honor's pronouncement that there was a basis here to interpret the constitutionality of Section 22, Order 60, as well as Article 177, in order to ascertain if the chair and GECOM were acting lawfully, to my mind, runs contrary to well-settled jurisprudence. C.C. Kumar Singh and Butler, Petrie and the AG, Christopher Ram and the AG, CCJ, and Chaitan and the Attorney General. Her Honor's view was in no doubt prompted by the pronouncement of the majority in Moore's case. At paragraph 108, it is stated, on the main issue in this appeal, we have found that jurisdiction of the High Court can be exercised to grant relief during the elections process in spite of Section 141 of the RPA. That jurisdiction can be exercised where the court is satisfied that GECOM has acted or is about to act in excess of its constitutional and or statutory powers. My lone wolf-like dissenting opinion in Olita Moore case is well known, and I continue to harbor reservations as to the correctness of the majority's analysis leading to their opinion as reflected above. See paragraphs 24 to 27 of that dissenting opinion. I continue to hold the view that those are matters that fall squarely within the jurisdiction of an elections court, pursuant to Article 163, and more specifically, B1, unlawful acts or omissions. Of course, after the elections process is completed. My position in this regard has been consistent throughout the elections-related litigation that has engaged the attention of this court. This, to my mind, is in keeping with the settled jurisprudence reflected in the cases referred to earlier. See, in this regard, see my dissents in Ram against the AG and others, the no confidence motion, Moore against GECOM, and David against GECOM. This, to my mind, accords with the general scheme of elections legislation in Guyana, which only permits a challenge after the process is completed. See Ali and Jagdeo against David. The inviolability of Section 140 and Article 163 of the Constitution must be preserved. The need for certainty as it relates to our election laws and processes is paramount. To whittle away the sanctity of those laws and the well-settled jurisprudence attended thereto would only serve the purpose of disruptive opportunism, which must be eschewed. This, to my mind, is the primary mischief that our election laws sought to repel. Sitting in a court of coordinate jurisdiction, I do not consider myself bound by the majority in Moore. I'm fully cognizant, however, of the need for caution in this regard. See Ying versus Song, 2009 NSWC. My position is reflective of the law as I comprehend it. The issues raised by the appellant is simply unsustainable in judicial review proceedings. However, the limited jurisdiction specified by me earlier allows for intervention. I may be wrong. I may be wrong. However, and in any event, the majority and more clearly stated, as highlighted earlier, that issues relating to Article 177, Section 99 of the RPA, and the constitutionality of Section 22 effectively falls within Section 140 of the RPA, as they are within the responsibilities of GECOM in the management of the elections process. Additionally, the reference to Petrie, Sikumar Singh, and Chaitan as it relates to challenges to the constitutionality of elections-related legislation and its disruptive effect, if not perused by elections petition, is of significance. The majority decision must be read as a whole. This, to my mind, had binding effect on the lower court as it relates to that article and those sections. In concluding on this aspect, I reiterate that the peculiar circumstances of this case, judicial review is necessary to address the impasse in order to complete the elections process. This limited jurisdiction could not be properly invoked in order to resolve any questions as to the validity of an election itself. That falls squarely within the jurisdiction of an elections court pursuant to Section 140 of the RPA, Article 163 of the Constitution, and its attendant rules after an election is declared. I'm not minded to extend the court's jurisdiction in judicial review proceedings beyond that limited scope. Notwithstanding and having regard to the circumstances of this case, it would be prudent of me to consider, albeit briefly, the remaining issues that base the applicant's claim for relief, which fell for her honest determination, having assumed an extended jurisdiction, as she understandably did. Issue estoppel stare decisis res judicata. In Halsbury's Laws of England, 5th edition, volume 12, at paragraph 1591, it is generally noted, and it's recited here, and we're all familiar with it. C2 Garraway and Williams, for the traditional formula as it relates to res judicata. Again, in the state of Kammataka against All India Manufacturers, AIR 2006, Sri Krishna J. stated, and I've recited it here, I would not repeat it. The reference in this case to public interest litigation is of importance, as all are seemingly in agreement that such litigation engages our attention here. The expansive scope of these concepts was highlighted in Henderson and Henderson, in which it is stated that res judicata applies except in special cases, not only to points upon which the court was actually required by the parties to form an opinion and pronounce on a judgment, but to every point which properly belonged to the subject of the litigation. Additionally, and of significant importance, in cases where res is not strictly established, where estoppel per rem judicatum has not been sufficiently pleaded or made out, but nevertheless the circumstances are such to render any re-agitation of the question formally adjudicated upon a scandal and an abuse of the court in its inherent jurisdiction, the court in its inherent jurisdiction will not hesitate to dismiss the action. See the Doctrine of Res Judicata by Bauer and Turner, 2nd edition, paragraph 503 to 505, edit inherent jurisdiction of the court. C2 Yang against Song, 2009, NSWC 1344 for Ward J, as he discusses the issue of obiter dicta and the great weight to be attached thereto. Fundamental to these concepts and inextricably interwoven in the general concept is the general concept, of stare decisis. The scope and ambit ought to be well known to all, but as a reminder, it is a principle that courts in common law will follow previously decided cases as much as possible and avoid upsetting precedents. Stand by things decided, as it were. It is substantially against this backdrop and in this context that the substantive issues, especially as it relates to Order 60 and Section 22 DLA, fall for consideration. To my mind, public interest litigation, as is the case here, which is binding on the public, is incapable of attracting the strict traditional private law res judicata formula, as highlighted in the Garraway and Williams case referred to earlier. Now, these principles highlighted must be strictly adhered to, lest we beckon chaos in the hierarchical structure of our judicial system and perpetuate never-ending litigation on the same issues. Her honest comparative analysis of the relief sought in Moore vis-a-vis those in the instant matter, and her finding that though couched in different terms, they were in effect similar and same in some instances, is apt and telling in this context. See paragraph 79 of Her Honor's decision. Now, Section 22 of the Elections Law Amendment Act number 15 of 2000. Section 22 provides as follows, and I've recited it, I won't repeat it. The issue of the constitutionality of Section 22 was previously addressed by this court in Ulita Moore case. At paragraph 67 and 68 of the majority identified the main arguments for and against the constitutionality of Section 22. At paragraphs 106 and 107, recited in full earlier, the majority held that the legality of Section 22 is a matter to be frontally examined by the court at a full hearing. Of significance, reference was made to Petrie, Sikumar, Singh, and Chaitan's cases in eschewing disruption to the elections process and allocating that to an election petition. Additionally, in my dissenting opinion with reference to the constitutionality of Section 22, I refer to at paragraph 31, and I've recited it here, it's well known. This court was ad idem on the issue which formed a part of the ratio decidendi, albeit for differing reasons. It is clear that the appeal court definitively concluded that it lacked jurisdiction to determine the constitutionality of Section 22, and thus avoided trampling on the elections, on the jurisdiction of the elections court. As a pronouncement in rem, it is binding on all. In any event, it is to my mind a stretch to describe these proceedings as a full frontal hearing of the issue as contemplated by the appeal court, especially where substantial evidence may be required. In the circumstances, Her Honor was correct as a matter of law when she stated in paragraph 36 of her decision. But the decision of the Court of Appeal on Section 22 cannot be considered to be obiter or a passing statement or comment. The pronouncement of the Court of Appeal was definitive and a considered finding based on a point that was clearly argued. I am bound to give judicial weight as part of the ratio decidendi or reasoning of the court rather than obiter dictum. I see no merit in the appellant's contention in this regard. Order 60 and the recount. A determination of these issues requires a consideration of the impact of the decision of our apex court in Ali and Jagdeo against David, GY Civil Appeal 421 of 2020. At paragraph 35 of its decision, the CCJ referring to Ali and Jagdeo's appeal obviously posited that a determination of the merits of their appeal requires us to A, consider the legal and constitutional scheme for elections in Guyana, and B, to interrogate more closely the provisions of Article 177. Clear and ultimately decisive context is achieved here. Unconstitutionality, to my mind, is an inherent consideration of the legal and constitutional scheme for elections in Guyana, as referred to by the CCJ. Reliance on the validity of Order 60 in David's case and its rejection as unconstitutional here, as an afterthought, seemingly, is a classic case of an abuse of the court's process, which must be rejected. The CCJ, throughout its decision, anatomized Order 60, excruciatingly explaining its purport, intent, and transparent processes, and emphatically endorsed it as part of the existing legislative scheme governing the March 2nd, 2020 elections in Guyana. For example, at paragraph 38, the CCJ stated categorically, it was specifically introduced to cater for the various disputes and contentions that arose after polling day. The intention was to provide an open, transparent, and accountable recount of all the votes cast in those elections. The purpose was to assuage the contestations among the various parties and determine a final and credible count and remove certain difficulties or fill certain gaps in connection with the application of the provisions of the Representation of the People's Act. In addition, it is of significance that the CCJ held that Order 60 did not create a new electoral regime in Guyana, but stressed that it only related to the March 2nd, 2020 elections. Further, in its analysis, there was a clear consideration of the allegations of irregularity, voter impersonation, and fraud. In this context, the CCJ reaffirmed that those challenges could only be brought pursuant to the Article 163 jurisdiction after the elections process was completed. The CCJ stressed that unless and until an elections court decides otherwise, the votes already counted by the recount process as valid votes are incapable of being declared invalid by any person or authority. See paragraphs 36 to 46 of that decision. The decision must be read as a whole in order to fully appreciate its impact on those issues. On this aspect, the majority decision and more must also be noted. It is clearly stated that issues and contentions in relation to the then proposed recount would fall squarely within the jurisdiction of an elections court. See paragraphs 85 to 89. This issue has, to my mind, been definitively and conclusively pronounced upon. Suffice it to say that I agree fully with our honest, comprehensive analysis and conclusion on that issue. Declarations by the returning officers and the powers of the CEO. The peculiar aftermath of the March 2nd, 2020 elections, resulting in the lawful advent of Order 60, in an effort to provide an open, transparent, and accountable recount of votes validly cast, thus enabling the delivery of elections results, and its endorsement by our apex court, to my mind, necessarily meant that the declarations of the returning officers made pursuant to Section 84 of the RPA were, as the Chief Justice put it, overtaken by events. Simply put, the Section 84 declarations can no longer be the basis of ascertaining the results of the March 2020 election. This is, to my mind, what the chair of GECOM was alluding to in her pronouncement and guidance to the CEO as it related to those declarations. A contextual understanding of the purpose of Order 60 is crucial. Paragraph 38 of the CCJ's decision in Ali and Jagdeo referred to early is pellucid. The contentions that it has retrospective effect and that the chair of GECOM trampled upon the jurisdiction of the elections court in setting aside those declarations is misconceived, to say the least, and thus rejected. The chief elections officer holds a statutory office and is subject to the disciplinary control, guidance, and direction of the Commission. The legislative scheme so provides, pursuant to Article 161 of the Constitution, Sections 2, 7, 9, 13, 14, and 16 of the RPA, and Sections 18 and 19 of the ELA. Section 18 of the ELA, recited in Order 60, specifically provides that the CEO shall, notwithstanding anything in any written law, be subject to the direction and control of the Commission, and, if I may add, only the Commission. Clear and unambiguous language. Section 19 of the ELA provides for the removal of any doubt. It is hereby declared that the power of the Commission to supervise the functioning of any election officer shall include the power to issue directions to any such officer. The CEO falls within the definition of an elections officer. Simply put, the CEO is an employee of the Commission. The history and evolution of the reforms to the RPA effectively whittling down the powers of the CEO and enhancing those of the Commission, as highlighted by Senior Counsel Ramkaran in his submissions, is illuminating and, of course, worthy of note. Now, Section 96(1) and 2 of the RPA mandates that the CEO, after calculating the total number of valid votes of electors cast for each list of candidates, shall prepare a report in manual and in electronic form in terms of Section 99 for the benefit of the Commission, and allocate seats in the National Assembly to members on those lists in accordance with the formula set out in Sections 97 and 98. This represents, in essence, his mandate. As referred to earlier in the CCJ's decision in the Alice case, unless and until an election court decides otherwise, the votes already counted in the recount process are incapable of being declared invalid by any person or authority. Again, in a stinging rebuke at paragraph 47, the CCJ said, the idea that the CEO or GECOM could, in an unaccountable, non-transparent, and seemingly arbitrary manner, without the due processes and legal standard established in Article 163 and in the Validation Act, disenfranchise scores of thousands of electors is entirely inconsistent with the constitutional framework. Whatever allegations of irregularity of these votes must be adjudged by the High Court under Article 163, as was correctly stated by the chairperson of GECOM. The CEO's powers are derived from the RPA. The contention that he is clothed with constitutional authority under Article 177 is simply not the case. The Commission is clothed with such authority by virtue of Articles 161 and 162 of the Constitution. The clear distinction between the Commission and its employees must be appreciated as a basis of conceptualizing the CEO's role and function. This distinction will also impact the court's jurisdiction, which will be dependent on the nature of claims brought involving the Commission or its employees. It is also important to note that by virtue of Article 226(1), GECOM shall not be subject to the direction or control of any person or authority. In the peculiar context of our present legislative scheme governing the elections, the advice referred to in Article 177(2)(b) is to be construed to mean that GECOM is not to act on the advice of any person or authority external to the Commission. I agree with Her Honor in this regard. The advice contemplated must be lawful and in accordance with the prevailing law, which includes Order 60 as endorsed by the CCJ. The Commission cannot be expected to accept advice known to be unlawful or lacking in legitimacy and act upon it. Such a proposition is absurd and is squarely rejected. See Ulufa Alu, Prime Minister against the Governor General, 2001-1 LRC 425 at 432. In addition, and considered in context, I cannot conceive of any issue as the constitutionality of Section 18 of the ELA. I am in full agreement with Her Honor in this regard. The CEO is duty-bound in the peculiar context of these elections to prepare and present his report based on the results of the recount as instructed by the chair. There is simply neither power nor authority reposed in him to act otherwise. He certainly cannot act outside the scope of the guidance and directions of the Commission as he purports to do, as he is not endowed with any semblance of discretionary power or authority. In this regard, I agree with the analysis of Her Honor, as it properly and effectually resolved the impasse which afflicted the elections process and stalled the completion, however untenable that impasse may have been. In the circumstances and having regard to all that I have said, this appeal dated the 21st day of July 2020 is dismissed. The cross appeal by the fourth named respondent dated 22nd of July, which in essence supports the appellant's appeal, is also dismissed. The cross appeal by the seventh and eighth respondents dated 22nd of July 2020 is allowed to the extent of the court's limited jurisdiction in judicial review proceedings in an ongoing elections process, as specified by me in this decision.
Introduction. This case stems from an impasse at the Guyana Elections Commission, GECOM. GECOM, through its chairperson, has requested the Chief Elections Officer, the CEO, to submit his report, upon which basis the declaration of the results of the national and regional elections is to be made in accordance with Article 177 2B of the Constitution and Section 99 of the Representation of the People Act, Chapter 103. The CEO has submitted a report other than the report which he was instructed by the chairperson to prepare. In June, at the conclusion of the national recount of votes, GECOM decided to use the results as shown in statements of recount to declare the results of the elections held on the 2nd of March 2020. Following that decision, the chairperson wrote to the Chief Elections Officer requesting him to prepare his report. There followed an application to the court, this court, by Eslin David, in which the applicant complained that GECOM had failed to act in accordance with Order 60 of 2020, under which the recount had been held. The CEO thereafter submitted a report on the 23rd of June, which was deemed null and void by the Caribbean Court of Justice in the appeal of Ali and Jagdio against Eslin David and others. On the 10th of July, after an exchange of letters between the chairperson and the CEO submitted a report based on the reports of the 10 district returning officers. To date, the CEO has not submitted the report requested by the chairperson. No declaration of the results of the election has been made by GECOM under Article 177 2B or Section 99. In short, and so far as is material, Article 177 2B of the Constitution provides that the declaration of the results of the election is made by the chairperson of GECOM, acting only in accordance with the advice of the CEO, after such advice has been tendered to GECOM at a duly summoned meeting. Section 99 provides for the publication of the results of the election and, among other things, the allocation of seats in the National Assembly. The national and regional elections of the 2nd of March 2020 have spawned 4 court actions. Apart from the 2 cases, Eslin David and the current proceedings, which were brought after GECOM's decision to use the results of the recount to declare the winner of the election, 2 earlier proceedings engaged the attention of the courts. In March, Riaz Holadar obtained relief against the returning officer for Region 4 for non-compliance with the statutory procedures for the declaration of results in that district. The controversies which arose at that time were not resolved, and as was undertaken by the chairperson to the High Court, these controversies led to the decision by GECOM to hold a national recount. Yulita Moore then approached the High Court to challenge the proposed recount. That matter was eventually appealed to the Court of Appeal. In that case, and in the course of all 4 proceedings, several issues were adjudicated upon, and the parties in the current case have all drawn on these cases. It is contended by the respondents, with the exception of the Attorney General, that the current proceedings attempt to relitigate issues which have already been settled in the earlier proceedings, more particularly by the Caribbean Court of Justice in Ali and Jagdeo against Eslin David, and by this court in Yulita Moore against GECOM and others. On the other hand, the appellant and the Attorney General rely on the decision of the Caribbean Court of Justice in Ali and Jagdeo as the basis of their challenge to Order 60 of 2020 and the recount process which it regulated. The decision of the Chief Justice. The Chief Justice found that the High Court had a narrow supervisory jurisdiction which could be invoked in the circumstances of this case, where there is an impasse regarding the decision-making of GECOM to complete the election process, and where it was necessary to advance the process. The court was of the view that the applicant was really seeking the interpretation of the Constitution for a determination of whether the chairperson and the CEO were acting lawfully in that context. Applying the decision of Holadar and Moore, the High Court was held to have jurisdiction to ensure the correct and smooth operation of the progress of the election process. The claims made in the fixed date application were considered, and it was found that 1, challenges to the constitutionality of Section 22 of the Election Laws Amendment Act had been definitively resolved by the Court of Appeal in Moore to be a matter for the determination of the High Court under Article 163 of the Constitution. As such, this issue was res judicata. Secondly, as to the challenge to Order 60, the learned Chief Justice found that the Caribbean Court of Justice had not nullified the order and the recount process, which had been undertaken under it. The Chief Justice found that the Caribbean Court of Justice had explicitly endorsed Order 60 and the recount process in Ali and Jagdeo and against Eslin David and others. Additionally, the Chief Justice found that the Court of Appeal in Moore had held that the lawfulness of the recount was an issue to be determined in an election petition on Article 163 of the Constitution. Hence, it could not be concluded at this time that Order 60 and the recount held under it was invalid. And therefore, the issue as to the constitutionality and lawfulness of the recount was also res judicata. As to the roles under Section 18 of the Election Laws Amendment Act, which provided, and I quote, the Chief Election Officer and the Commissioner of Registration shall, notwithstanding anything in any written law, be subject to the direction and control of the Commission. The Chief Justice found that it was GECOM and the chairperson that had a constitutional mandate and not the CEO, who is a functionary of GECOM pursuant to Article 161A and Sections 2 and 7 of the Representation of the People Act. And the court agreed with the submission that Article 177 2B can be construed to mean that GECOM is not to act on the advice of any person or body external to the Commission. Section 18 of the ELA was held not to be unconstitutional or in conflict with Article 177 2B. It was further held that the reports of the 10 returning officers could not be resurrected to form the basis of the CEO's report to the chairperson for the declaration of the results of the election. In effect, the High Court endorsed the position of GECOM and its chairperson that it was within the Commission's powers to decide that the recount and the results therefrom must stand as the basis for the final declaration of the results of the election held on the 2nd of March, 2020. Appeal and cross appeals. The combined issues raised in the main appeal and the 2 cross appeals complain about all of the main findings made by the Chief Justice. Critically, the grounds of appeal of the appellant and those of the Attorney General focus primarily on Section 22 of the ELA, which gave birth to the recount order, Order 60 of 2020. Those parties also challenged the findings on the authority of the CEO in the performance of his functions on the Section 18 and the presentation of his report under Article 177 2B. The 7th and 8th respondents focus on the issues of res judicata and judicial precedent, whereby they say that the issues that have been raised in this application or in the application of Misenga Jones to the High Court have been dealt with and settled in earlier proceedings. And those issues include definitive findings on the limits of the court's jurisdiction to inquire into the performance of GECOM's functions. Analysis of the issues in the appeal. Order 60 of 2020 and the recount process it engendered is the heart of this case. It's at the heart of this case. Thus, this case focuses upon the powers of GECOM, in carrying out its mandate under Article 62 and 162 of the Constitution. The question of GECOM's powers first arose in relation to the election of March 2nd, 2020, when the recount was first proposed. It was contended that Section 141 of the Representation of the People Act operated to shield the acts and omissions of GECOM in the carrying out of its functions. The court in Ulita Moore, that's the majority of this court, upheld the submission that Section 140 operated as a shield for GECOM in the circumstances which prevailed. As such, the court had no jurisdiction to prevent GECOM from proceeding with the proposed recount at that time. Section 140 of the Representation of the People Act may be quickly mentioned, except to the extent that jurisdiction has been conferred and the exercise thereof is required by the Constitution or any other law under Article 163. No question I'll read that again. Except to the extent that jurisdiction has been conferred and the exercise thereof is required by the Constitution or any law made under Article 163 thereof, which provides for the determination by the Supreme Court of Judicature of questions as to membership of the National Assembly and elections thereof, no question whether any function of the Elections Commission or of any of its members has been validly performed or performed at all shall be inquired into in any court. Article 62 and 162 combine to provide that elections shall be independently supervised by the Elections Commission in accordance, Article 162 refers to Article 162. And Article 162 says that the Commission shall have such functions connected with or related to the conduct of elections as are conferred upon it by the Constitution or subject thereto any act of Parliament. And it goes on to provide that the Commission shall exercise general direction and supervision over the administration and conduct of the elections of members of the National Assembly and shall issue such instructions and take such action as appear to it necessary or expedient to ensure impartiality, fairness, and compliance with the provisions of the Constitution or any act of Parliament on the part of persons exercising powers under those laws. The evidence before the High Court at that time indicated, that's the affidavit evidence, that there were matters which were being addressed by GECOM, which related to the execution of its functions under Article 177 2B and Section 99. The specific issue was whether a recount should be held or whether the time had come to proceed to a declaration of the results instead. Further, whether GECOM should be compelled to declare results at that time instead of proceeding to a recount. This court held in Ulita Moore by a majority that the decision whether to hold a recount or not was a matter that was central to the elections and fell within the domain of GECOM to determine as part of its management of the elections process under Article 62 and 162 and related provisions. The court found that the functions performed in relation to those responsibilities would be shielded by Section 141 of the Representation of the People Act. The submission is therefore correct that this court has determined that the High Court has no jurisdiction to inquire into the lawfulness of the recount by virtue of Section 141 of the RPA. Likewise, the constitutionality of Section 22 of the Election Laws Amendment Act came up for consideration in the same case, as it was indicated that GECOM at that time intended to use its powers under Section 22 of the ELA to enable the recount. At paragraphs 106 and 107, this court referenced Petrie and the Attorney General and C. Kumar Singh and Butler, in which the High Court had declined to examine the constitutionality of election-related legislation during the election period, allocating, those cases had allocated such questions to an election petition. The court in C. Kumar Singh had said that such a determination would be disruptive of the election process. And this court further recognized that constitutional questions can be determined at the hearing of a petition. And this court referenced the discussion in the case of Peters and Chaitan against the Attorney General and another, Attorney General of Trinidad and Tobago and another. And so this court was guided by the jurisprudence in Petrie and in C. Kumar Singh when it declined to consider the question of the constitutionality of Section 22, which it regarded as election-related legislation, and the constitutionality of the recount. And it declined to do so during the election period and left that question for an election petition. It is now contended by the appellant in her submission of the 23rd of July 2020 that there now exists a sufficient evidential basis for such a determination on this point, and that is on the point of the constitutionality of the recount and the Section 22, under which the order 60 of 2020 was made. The appellant says the time has come for that evidence to be considered. According to her, Order 60, which was brought into being after the court's decision in Yulita Moore, is that evidence which justifies a consideration of the constitutionality point. I do not accept this submission because Order 60 was created from the powers exercised under Section 22 of the ELA. The order can only be deemed unconstitutional at an election court in the same way as the constitutionality of Section 22 itself. So I do not accept that there is any basis for now considering the constitutionality of Order 60, which has been brought into being under Section 22. In its judgment in Ali and Jagdeo and Eslin David, the Caribbean Court of Justice fortified this position when it stated that Order 60 now forms part of the electoral law in relation to the elections held in Guyana on the 2nd of March, 2020. So I do not accept the submission that Order 60 is unconstitutional because Section 22 of the ELA has not been deemed unconstitutional. It cannot be so deemed. That question must, that question has been determined by the court in Yulita Moore. For these reasons, I uphold the Chief Justice's ruling that the decision in Moore was definitive of the status of Section 22 of the ELA. Also, the High Court made further findings that the relief which had been claimed in these proceedings, those 29 claims which Misenga Jones took to the High Court, the Chief Justice found that those claims mirrored those made in the 3 cases. And those 3 cases that were identified as Julita Moore and Ali and Jagdio and Eslyn David. So it was found that there was a duplication of the claims. And to that extent, the findings on those claims were res judicata. And I'm satisfied that there is duplication in the claims brought by Misenga Jones with those brought by Julita Moore. The issue which cannot be raised, issues which cannot be raised and which, in my view, must be referred to an election petition. In this case, this is in relation to Misenga Jones. Those issues are as follows. And these findings are based on the application of the principles that were applied by the majority of the court in Julita Moore. So the claims which, in my view, are not justiciable at this time and must be referred to an election petition are claims as to the authority of GECOM and the chairperson to declare results pursuant to Section 96(1) of the Representation of the People Act and Article 177(2)(b) of the Constitution. The claims that the votes counted in the national recount did not conform to the concept of valid votes and were generated by an unconstitutional process. This too is a matter for determination by the Elections Commission, and as this was confirmed by the Caribbean Court of Justice in Ali and Jagdio and David. So to my mind, that question is not a question for the court to consider at this time, but it must be referred to the jurisdiction of the election court. Claims as to the constitutionality of Section 22, as I've just discussed, of the Election Law Amendment Act, not justiciable at this time. Claims as to the finality of the declarations made by the 10 district returning officers, and as to these declarations being the sole legal basis for the CEO's report pursuant to Section 99 of the Representation of the People Act and Article 177(2)(b). So in the same way as I'm of the view that the question of the validity of the recount votes must be ultimately a matter for the election court, by the same token, it is my view that the reports from the 10 district officers and as to whether they can form the basis of a declaration, that is an issue for an election petition and not for determination by the High Court in its supervisory jurisdiction. Also, orders setting aside the decision of the Guyana Elections Commission not to act on the advice of the CEO as contained in the letter of the 10th of July 2020. That would be a matter that right now is within the domain of GECOM to decide what, as I've already discussed, what information it wishes to use to declare the results of the elections. And the court has no jurisdiction to set aside its decision to reject the advice of the CEO as contained in his report of the 10th of July. That is for the election jurisdiction. And as I've said, my finding is that it is necessary that these questions be referred to the High Court in the exercise of its jurisdiction under Article 163 of the Constitution. And so, having found that these issues that I have just itemized are not for the consideration of the High Court as claimed by Misenga Jones, I move on to consider what are the remaining issues for, or what were the remaining issues for the determination of the High Court. And I'm of the view that the High Court has the jurisdiction to inquire into narrow issues arising in the application, some narrow issues arising in this application. But I do not agree with the submission of the 7th and 8th respondents that the High Court had no jurisdiction to inquire into any of the...
Our people, man.
Yes, as I was saying, I do not agree that the High Court had no jurisdiction to inquire into any of the issues except the roles as to Section 18 of the Electoral Laws Amendment Act. To my mind, the High Court's jurisdiction was a jurisdiction that enabled it to, that supervisory jurisdiction could have been exercised where there was evidence, as there is in this case, that the election process must be protected or smoothed. And other local examples exist where the High Court intervened during the process. This is the election process, to ensure that the process operated lawfully. And this is outside of the jurisdiction to be exercised under Article 163. And those examples are application by Aubrey Norton, where there was affidavit evidence that the chairman of GECOM at that time was about to act without consulting or meeting with other members of the commission. The High Court granted orders nisi of certiorari to quash the decision to make the declaration. The orders were later discharged on the swearing in of the president, as at that time, Article 177(6) operated to exclude the jurisdiction of the High Court. But the court was prepared to intervene to grant those orders nisi on the basis of the affidavit evidence, where it appeared to the court that the process was in need of protection, or as in this case, the process needed to be smoothed. See also Joseph Hamilton and Riaz Holidar, where it was alleged that there had been non-compliance with Section 84 of the Representation of the People Act, where the High Court intervened to grant relief. And I add to these examples, Ulita Moore, where this court held that the supervision of the recount appeared to be compromised, and that was on the basis of the affidavit evidence. And the court treated that issue of the supervision as a separate issue from the issue of the validity of the election itself. The court expressed the view and ordered that the commission, GECOM, could not surrender its supervision of the election process and any part of the process, more particularly the recount that was about to be undertaken. So all of these are local examples which illustrate the jurisprudence that the court does exercise, the High Court does exercise a limited jurisdiction, a narrow jurisdiction outside of Article 163, where there is evidence that the protection of the court, of the process, the election process is required. And in my view, the impasse that existed in, or still exists in this case, was such a circumstance that justified the intervention of the High Court. The intervention in this case is to advance the process and to provide clarity on the roles to be performed under Article 177 2B by the CEO, the chairperson, and the commission, and to explain the lines of authority between the CEO and the commission. I agree that there was jurisdiction to ensure the smooth operation of the election process in this case. And the High Court examined Section 18 of the Election Laws Amendment Act and the CEO's role under Article 177 2B. And in my view, the court was entitled to make the orders that it did in relation to how it saw the roles based on its examination of the pertinent provisions. I agree that the interpretation of the Constitution as part of this narrow jurisdiction might be too wide a description of the court's jurisdiction. But to my mind, when one examines what was done, the Constitution was not per se interpreted. The Constitution was examined in relation to Section 18 so as to understand how the Chief Elections Officer is to relate to the commission in the performance of his functions. So to my mind, it was an examination of the roles more than an interpretation of the Constitution. But I do agree that interpretation of the Constitution maybe is too wide a role or too wide a description of the narrow jurisdiction of the court. And I've looked at the findings of the court as to the process which is set out for the presentation of the report. And on the Section 96, when one examines how the roles of the functionaries are performed, on the Section 83 of the Representation of the People Act and Section 84, the process is set out for returning officers of all the districts across the country to furnish their reports to the CEO. And the CEO is the functionary who is allocated the responsibility of receiving those reports from the returning officers. This is under the statutory process. And from these reports, to calculate the number of votes cast for each list of candidates. And to use these reports to prepare his report that is required for presentation to the chairperson and the commission. And when one examines these roles, it appears to be a pyramid kind of arrangement where presiding officers across the country perform their functions at their polling stations and then submit the documents to the returning officers in the district, who then forward those documents to the Chief Elections Officer. And I see that requirement in Section Article 177 to be as based on that function, that the chief elections officer is the functionary who is tasked with the responsibility to receive those reports. And I agree that that function is not necessarily personal to the CEO, but relates to his office. But to my mind, the reference on the Article 177 to be that his report, that the commission is to act only on his advice as presented in his report, is based on that administrative system that is set out, as I've explained it, as I've examined it, the pyramid type of system. So from that, the CEO would calculate the number of votes cast for each list, and from that, present his report. So we come now to the recount. As I've said, it was within GECOM's powers to decide that they wish to use the results of the recount and to so instruct the CEO. The stipulations in Order 60 explain that the CEO was the functionary who was in charge of the recount process. And that process was undertaken at one location and not at disparate locations across the country. This was housed in one location, that process. And so to my mind, those arrangements would enable the chief elections officer to prepare a report for of the final results based on the tabulations at during the recount. And so I agree with the Chief Justice, her analysis of the roles. And I believe that it was within the jurisdiction of the High Court to make that determination and to make that assessment. And for clarity, I say under the recount, where all the data was handled in one location under the supervision of the CEO, there should be no difficulty for the report of the CEO on the tabulation to be prepared as requested by the Commission, as the Commission is within its powers, and those are its constitutional powers, and those powers are shielded under Section 140 of the Representation of the People Act. I have outlined the issues which have already been litigated and are res judicata. And essentially, I agree with the findings of the High Court on the issues of res judicata. And also, I agree, as I've said, that the jurisdiction in relation to the recount is not an issue that could be exercised by the High Court. I did not understand the Caribbean Court of Justice in Ali and David to have nullified the recount or Order 60 of 2020. And so my finding is that the court could have exercised the jurisdiction that it did in smoothing out the process, in analyzing the roles that are to be performed under Article 177 2B, Section 99, and Section 18 of the Election Laws Amendment Act, In my view, the jurisdiction was correctly exercised, subject to my findings in relation to the interpretation aspect, which I have already mentioned. So I would dismiss the appeal, and my full reasons will be incorporated in my written judgment. And so I would dismiss the appeal of the appellant as well as the fourth named respondent, the Attorney General. I will allow the appeal in part of the 7th and 8th to the extent that they are of the view that the High Court, my view is that the High Court had a very narrow jurisdiction, and it might have overstepped that jurisdiction in some of its findings. And so to the extent that they say that that jurisdiction was exceeded to some extent, I would allow the appeal in part. And so the judgments of the court will be made available very shortly to the parties. Thank you.
May, please, Your Honor.
Yes.
May, please, Your Honor. Your Honor, we thank you for your decision and the other justices that sat today. Your Honor, the issues are obviously important issues of national importance to the country. Our position on behalf of the applicant, Your Honor, is respectfully to ask for a stay of 3 days to consider the way forward and to consider Your Honor's decision. I recall that the court had, in the David's case, granted such an application. We're asking for nothing more than that.
The question is being asked if the stay is going to relate to a dismissal of the appeal. One member of the court is concerned that the stay is being asked, has expressed the concern that the stay is being asked in relation to a dismissal. Anything to say, Mr. Ford?
Your Honor, the stay is being asked in relation to what would be the obvious effect of the court's decision, Your Honor. The effect of the court's decision, having regard to where we are in the process, would mean that the Elections Commission and the instructions given to the CEO are to be acted upon. All we're asking, Your Honor, is an opportunity, as was granted in the David's case, for us to review the decision and to advise on the way forward. As I said, nothing more than was previously granted.
May it please, Your Honor.
May it please,
Your Honor, if I may, Your Honors did not grant any orders, and therefore there is nothing to stay. My friend seems to be placing heavy reliance on the David's case. In David's case, there was some sort of order made, and the effect of that was stayed. Here, the appeal filed by the appellant has been dismissed. So it is not legally possible for there to be a stay.
Please go ahead.
Yeah, so I'm saying, Your Honor, with the greatest of respect to my learned friend, there is simply nothing to stay. The court has simply dismissed the appeal filed by the appellant. And I'm just reiterating respectfully that in relation to David's case, the court had made a pronouncement based upon the case filed in that case. An interpretation was made by the court, and the effect of that interpretation was put on hold by the court. Here, there is no order, no interpretation, no guidance given, other than an order dismissing the appeal. And in this circumstance, Your Honor, with the greatest of respect, there is simply nothing to state.
Can we hear from Ms. Kite, please, on behalf of the commission?
Fair enough. I fully endorse what Mr. Nandalal has said to the court. Your Honor, nothing has been granted. There's nothing to be stayed. All that has happened is a dismissal of a frivolous and vexatious appeal. And that is our position. The work of GECOM must be completed, Your Honors. If we continue like this, when will we have election results 2025? This is untenable.
All
And
right,
I'm
Ms. Kite,
sure
could you
that friends
just
would
please
make this
focus
application.
on the, Ms. Kite, could you just help us with the application that is before the court? Are
Your
you-
Honors, grateful. We are
prepared
objecting.
to,
We're
Pardon me?
objecting to the application, Your Honor.
would any other party wish to say anything else?
Yes, please, Your
Your
Honor.
Honor, if I may, on behalf of the 12th respondent, if I may say to the court that I endorse what Mr. Nandlal has said, but I wish also to bring to the court's attention two things. Under the Caribbean Court of Justice Act, an appeal that will go to the Caribbean Court of Justice requires leave or special leave under sections 6, 7, and 8. We don't know whether that will in fact come into being. There has been no application filed. And in any event, if Mr. Ford would like to receive the benefit of any interim orders, as was the case in David, you have to file your application, and the approach should in fact be made to that court, not to this court. Because the only way for it to come into being with respect, Your Honor, is if there is an appeal in being. And with respect to this court, as this court is well aware, this court will have no opportunity or ability to bring an appeal into being without there being an application for such. So in addition to what Mr. Nandlal has said, we endorse that there is nothing to state, but we also say that as a matter of law, respectfully, Your Honor, even in David, the Caribbean Court of Justice, having been approached for an application for special leave, were also approached for the interim order that was made extant at that time. So respectfully, Your Honor, we believe that Mr. Ford's request could not be granted.
Your Honor, before you rule, Your
If
I
it
just
please, Your
wish to
Honor, may I also be heard? The 11th named respondent endorses what Mr. Dattadin just said, but also wishes to raise the point that this goes to this court's jurisdiction. The concept of execution of an order involves using the machinery of the court to enforce that order. There is no order sought. There is no order made by this court or by the court below, which prompts any requirement for using the machinery of the court to execute. As Mr. Dattadin said, given that no appeal is extant and that leave to appeal is required, there is, Your Honors having ruled, nothing jurisdictionally to permit any order, even if there was a coercive order in existence. There is nothing jurisdictionally to permit a stay because there is no leave yet granted for the appeal, and therefore there is no proceeding in being. Finally, the whole question of whether this court, even if it did have jurisdiction, which I respectfully submit it does not have, were to exercise its jurisdiction to grant such a non-existent stay, would depend on whether this court found there were real issues, live issues, a meaningful appeal, which potentially lay to the Caribbean court. And given that two justices have already ruled that these proceedings and this appeal is an abuse of the court's process, there is absolutely nothing to justify any exercise of that discretion. Finally, Your Honors, I would like to point out that what the Caribbean court granted, having granted leave to appeal in the David case, is not a stay. It granted a mandatory order
on an interlocutory basis, stopping Mr. Lowenfield from acting further. That is very different from a stay. The grant of an injunction on an interlocutory basis is very different from a stay. So there are three issues: the jurisdictional issue, the fact that there is no extant appeal and leave to appeal must be required, but also the discretionary issue that if you have here before you an abuse of the court's process, then by no stretch of the imagination can discretion be exercised even if they to grant a non-existent stay of a non-existent order.
Your Honor, just by way of response to the submissions made by my learned friend, firstly, Your Honor, the court is being asked to practically put its head in the sand and to pretend that there are no practical consequences, no judicial or constitutional consequences, which would flow from its decision. And I beg the court to recognize that this is not the situation. Secondly, Your Honor, in relation to the decision that was made by the court in Evelyn David's matter, I recall, and the record would show, that an application was made orally and the court granted a stay prior to any application being filed to the CCJ and any determination of a grant of an interim application before the CCJ. And by way of third point, Your Honor, the determination that the matter may be frivolous, that there may be no good grounds for an appeal, cannot destroy the application that is being made for the stay at this stage, Your Honor. The court will well be aware that in the matter of Erin Ford, which was decided by Justice McGarry, Vice Chancellor McGarry, he indicated that even when a court is satisfied that the application is absolutely without merit, without basis and any foundation whatsoever, that in instances where the party may wish to consider an appeal or wish to consider the way forward, that it would be appropriate to grant some interim relief, even though how satisfied the court would be of the accuracy and soundness of its own decision. So, Your Honor, I rest my submission and prayer for the order that I have asked for.
What's your position? Well, two members of the court do not wish to grant your application. Let me speak for myself. I would have been prepared to grant you a short stay for 1 day. But the court's position, the majority position today in relation to your application is to deny it. So your application is denied.
May I ask if the court is minded to consider the question of costs, Your Honor?
Do you have an application in relation to costs?
At your discretion, please.
Mr. Ford, anything to say on the issue of costs?
No, please, Your Honor.
Well, Your Honor, speaking for the 7th and 8th, may I respectfully suggest, Your Honor, the conservative sum of $2 million? Your Honors, each of the judges in today's hearing have identified specifically and at length addressed the question of res judicata. Many times you've heard the term abuse of process, etc., etc. One judge, I believe, reiterated this is the 4th incarnation of challenges to the electoral process. Your Honor, all these things, they're being relitigated over and over again. And the court is, in fact, enjoined to express its displeasure in some form of punitive expression. And I'm asking respectfully, Your Honor, speaking for the 7th and 8th respondents, that the sum of $2 million be considered adequate.
For the 9th, please, Your Honors, I would endorse Mr. Nandalal's submission and ask also that the cost paid to all respondents before anything further is filed.
If it pleases Your Honor, on behalf of the 12th respondent, I endorse what both Mr. Nandlal and Mr. Ramkaran has said.
Your Honor, on behalf of the fourth respondent, may I be permitted to complete my submissions? I understand that the system was disconnected while I was speaking.
Pardon me, Mr. Edwards?
May I
No,
be
we didn't
permitted
hear you. We
to
didn't
complete
hear
my
what you said.
submissions? Yeah, I understand the system was disconnected while I was speaking. May I be permitted to complete my submission?
On costs?
No, Your Honor, on the very question of the stay, on the very
Oh, I
question.
didn't know you were making,
Yes, Your Honor.
you're asking the court to go back on its ruling. Two members of the court say no. And so that is the decision of the court.
Yeah, but Your Honor, my submissions were not completed for the records. I would like it to be completed for the records.
Yes, please go ahead then.
Yeah, thank you, Your Honor. The point I was making, Your Honor, is that the submissions of my learned friends, both Mr. Nandalal and Mr. Jones, are incorrect in law and wholly erroneous. This court, in Caribbean Chemicals, they had granted a stay under circumstances not totally unanalogous to this matter. And I would further submit, Your Honor, that this court, as an intermediate court, this court is not a final court. Under the doctrine of stare decisis, this court is bound by its own decision. And I respectfully urge Your Honors to be guided by this court decision in Caribbean Chemicals, in which the present chancellor acting, she dissented, but the majority did rule that they have a jurisdiction to grant a stay, irrespective of whether it was in relation to orders or declarations. And Mr. Landalal is very well aware of that decision. You must be aware of that decision.
Mr. Williams should have permitted you to speak at the appropriate
I
time.
was speaking, but the system disconnected me. I don't know if there's some shenanigans going on.
I don't know if the court will hear. If the court will hear us, I will answer you.
Mr. Landalal, Mr. Williams does not have to permit me to speak. I'm co-counsel in this matter with the Lord and Attorney General. And I have been assigned certain duties and certain roles, and this is one of them. So please don't interrupt.
All right, the transcript will reflect your submissions on the point, Mr. Edwards.
So having regards to what I've just submitted, Your Honors, you're not minded to revisit the question, Your Honors? Mr. Danda is well aware of Caribbean Chemicals. And I presume to Mr. Jones.
All right, well,
You're asking for a very short stay, Your Honors, very short stay.
the commission, as the judgments have all pronounced, the commission's authority at this time has been affirmed by all the judges. We essentially have placed all the matters back or in the hands of the commission. That is why Counsel Ms. Kite was asked whether she had anything to say, but I recall that in previous proceedings, Ms. Kite had indicated that the commission's practice has been to await proceedings, but she now has, to her benefit, a dismissal. So Ms. Kite has held out that she's objecting to this application for.
Your Honors are entitled to overrule Ms. Kite because this is a matter of such fundamental and supreme constitutional.
Well,
Ms. Kite is not the authority on this.
Grant you one day.
Thank you, Your Honor.
Mr. Edwards.
Yes, Your Honors.
And Mr. Ford, the court will grant you a day to consider your position.
Thank you very much, Your Honor.
Well, would you like to?
Expiring at what time?
Sorry, for the record, I must just say that is not my decision. My decision is to refuse the application for a stay. I would just like that to be noted on the record.
Your Honor,
I would like
to also respect to the question of cost.
No, we're still at the question of the stay.
Oh,
we're still
I'm
at the
sorry.
question of the stay. The record will reflect that two of the judges are prepared to grant a stay for one day. So that's the position on the stay.
Your
And so
Honor,
that stay will expire in 24 hours.
Your Honor, just to be clear, what
A stay of the effect of the judgment of the court. That's what I understand the application to be.
which is the dismissal of the appeal?
That means that the appeal is pending. That doesn't mean anything.
I'm just clarifying, Your Honors, what is being stated.
It just
Question
means
of
that
costs. The question of costs.
Your Honor, the appellant wishes to point out that we had instituted proceedings against 4 people. The remaining 8 people chose to join these proceedings. They petitioned the court. This matter could have been determined without the participation of the additional respondents. It would be grossly unfair to have people tag along, join in proceedings, and then ask to have costs awarded in their favor when the proceedings are over. Your Honor, this line could have been much longer, and it would have been grossly
How much
unfair.
cost will you offer then? How much cost are you offering?
Your Honor, fundamentally, we're saying that no consideration of cost should be made beyond the people who were sued by the appellant. And those are
Okay,
the
we
first.
can hear submissions on costs. So we can consider your submissions on costs in a few days. Can give each of the parties 3 days to make submissions on costs. So that's the
Thanks,
order
Rob.
of the court.
Thanks, Your Honor.
When we get those submissions, we will make a finding and an order on costs. Thank you.
Good rise.
Kaieteur Radio.
Covering Guyana from coast to coast.
Demerara and Essequibo 99.1 FM.
Berbice 99.